So Tom, the new offence of assaulting an emergency worker. How's that different to the old one of assaulting a police officer?
Well, the first interesting thing about it is, although we refer to it, or you've just referred to it as the old offence, it still exists, the offence of assaulting a police officer. And so the two of them are running alongside each other, which is unusual in criminal offences, where you've got two offences covering essentially the same course of alleged conduct. The CPS guidance is that the older offence of assaulting a police officer shouldn't be used. The new offence is different in procedural terms because it's an either way offence. There's a higher maximum penalty, and that's currently 12 months. It may increase, and there's talk of it being increased further. Whether or not that comes to pass, we don't know. Another important difference that's obvious from the name perhaps is that it applies to people other than police officers. So it applies to other emergency workers, and they're defined in the legislation, and they include, for example, fire officers, ambulance drivers, and so on. They include perhaps a wider definition of police officer, and they include someone engaged to provide services for police purposes, which is quite a broad definition. But the crucial and I think the interesting question is going to be whether or not acting in the exercise of their functions, which is what the prosecution have to prove in the new offence, is treated differently to acting in the course of their duty, which was the element of the old offence. Now, they don't sound very different, but in the course of the bill passing through Parliament, it was suggested that the new offence would be wider. The CPS guidance suggests that the new offence is a wider test and would capture some actions by police which weren't captured before. But my view is I don't think that that's right. I think it would be unusual because, as I say, the old offence is still in force, and not only the old offence of assaulting a police officer, but the offence of obstructing a police officer in the execution of their duty is still in force, and that would still be charged in a number of cases. And so you could potentially end up with some odd results if you have different tests as to whether an officer is in the execution of their duty or in the exercise of their functions, bearing in mind that you could have someone charged with obstructing a police officer and assaulting an emergency worker in the course of the same set of allegations, the same course of events. And as a matter of principle, it isn't any part of a police officer's function to act outside the execution of their duty. It's not any part of an officer's function to commit offences or to commit trespass, which was part of the definition of the old offence as to when they crossed the line. And so in principle and in practical terms, I don't see how it can and should be any different.
Yes, it sounds as though if a magistrate did decide that functions meant something different to duties, then there would be a High Court case in the making.
Oh, definitely. I think there's a really interesting point to be argued there as to how they would effectively start afresh with this new offence and throw away all of the myriad of case law that's built up around the old offence.
When you were introducing the new offence, you said it was an either way offence, so it can be tried in the Magistrates' Court or the Crown Court. Is there a rule of thumb for clients, if they're unrepresented, or for practitioners, as to what might be the better court to be tried in?
Well, obviously each case depends on its own facts, but if there is an issue about whether or not a police officer was acting in the exercise of their duty, whether they were behaving properly, ordinarily one would lean towards a trial before a jury who are more receptive to defendants and less case hardened, less cynical perhaps than magistrates, and the magistrates' court has a conviction rate which normally floats around the 98-99%. So for those reasons, if there is an opportunity to get the case into the Crown Court, that's normally the place where one has the best chance of a fairer hearing.
And sentence-wise, would it be fairly similar in the Crown Court and the Magistrates' Court?
Well, the difficulty is that magistrates can, even if they keep the case for the trial, then commit it for sentence later on. And so the sentence may not end up being the same, and if the matter stayed in the magistrates' court, then the defendants really just lost their opportunity to a trial by jury by agreeing for it to stay there. The effect on sentence isn't going to be much in the vast majority of cases, if anything.
Thank you, that's really helpful to know.